session.
Good afternoon, everyone.
Please be seated.
I am Justice Eileen Moore. To my right is Justice Thomas Delaney, and to my left is Justice Martha Gooding. We have two matters on calendar this afternoon, and we have two different panels. This panel will hear the first case, take a very brief recess, and for a panel change, and the second case will be heard forthwith. The first matter is Orange County Media Tower versus Louis Galuppo. You may proceed.
Good afternoon, Your Honors. May it please the Court. My name is Daniel Watts. I represent the appellants Louis Galuppo, G10 Galuppo Law, Plaza del Sol Real Estate Trust, and Morris Cirillo World Evangelism. I'd like to reserve 5 minutes for rebuttal, please.
All right.
So we have here an anti-SLAPP motion to strike that was denied in the trial court. We're asking this court to grant that anti-SLAPP motion to strike. The anti-SLAPP procedure is a two-pronged procedure. The first prong is the most interesting and the most important here in this case because the second prong I think is pretty clear, the merits prong, that there are defects with the complaint. But on the first prong, which is where the trial court denied it, any statement that is made that has reasonable relevancy to anticipated or actual litigation satisfies that first prong. So what the trial court, the error there was not looking at the supporting and opposing affidavits that gave context to this. The sole act, the sole wrongful act that my clients are accused of is sending a demand for money, a demand for about $24,000 in attorney's fees. If you look at the cross-complaint.
Well, isn't it sending a false demand?
It
Or
is
allegedly false?
It is sending a demand that they allege was false, yes. So our clients sent a demand for money. And that demand for money, the cross-complaint does not say who read it. It doesn't say exactly who sent it. It says it was sent. It doesn't elaborate on who actually received it or read it. So it's very vague. You don't really know the context that it was sent in. And so the Supreme Court in Equilon Enterprises says that when an allegation in the complaint doesn't obviously arise out of pre-litigation activity, then we must look at the supporting and opposing affidavits. Those affidavits are the ones that we submitted from Louis Galuppo. That affidavit provides the context. It shows that this demand was sent, and it was sent in anticipation of litigation that was reasonably anticipated, as we can see from the fact that we are in it right now. So the demand doesn't have to expressly threaten litigation. There are no magic words that it has to include. As the court in Aronson versus Kinsella says, saying that a demand was sent in good faith and serious consideration of litigation, that just means that the statement that was made has some connection or logical relation to the action that's contemplated. In other words, if the statement is made with a good faith belief in a legally viable claim, and in serious contemplation of litigation, then the statement is sufficiently connected to litigation.
Mr. Watts,
Yes.
Then let me ask you, what does the record show, if anything, about any demand for payment or mention of litigation in the context of the invoice?
The demand shows that this invoice followed, so first of all, it's an invoice for attorney's fees that were incurred trying to get them to remedy a breach of contract. They had taken out a very large loan, tens of millions of dollars. They didn't pay it, and the parties spent almost a year trying to get them to pay it. In the record, if we can go through the timeline. September 18th, 2019, there was a letter internally, this was a letter from our client Morris Cirillo to Mr. Hera on page 138 and 139, saying that showing that there had been negotiations. We agree to the payoff demands listed above, but the above dates and actions are not acceptable to Plaza del Sol. It's been 18 months since these loans / joint venture. You've been in default, saying that they're in default under an obligation. We worked with you, but we're in a desperate situation now. That's September 18th. Just a couple weeks later, on October 2nd, we have a letter from one of our client's principals to another on page 141 of the record, saying yesterday there was a meeting to discuss the repayment of the Hera loans. Alliance attorneys were involved. That's another case. There were discussions of foreclosing on these two properties. What one of our client's officers, Roger, says Roger had met with a real estate attorney in Santa Ana, as I understand it, who would draft foreclosure documents for us. Roger shared that he had told Mike, the other side here, told Mike that if he couldn't move quickly, we would be forced to foreclose. Mike's response was that he would not turn over the properties to us without a fight. He threatened to file bankruptcy to delay and possibly prevent us from getting these properties. We need to count the costs before we file foreclosure. What will our legal costs be? That was page 141 of the record. So it was clear from these contemporaneous discussions that both sides were threatening to file litigation over this. Then in May 22nd of 2020, this is again 5 months later and 4.5 months before this demand was sent, we didn't just have Louis Galuppo's declaration here. Our client got a second opinion from another attorney. We had an internal legal memo here that's on the record at page 177 and 178. This other attorney, Christopher Lamb, says there's 3 different methods by which we can try to recover this outstanding obligations. They're in breach here. One is judicial foreclosure. One is non-judicial foreclosure, and then they talk about appointing a receiver and some other things. They say that in a judicial foreclosure, a creditor brings a lawsuit against the debtor to force a sale of the real property. That's an exact quote from page 178. Shows that our client was seriously considering filing what is described here as a lawsuit against the debtor, this very lawsuit that we're in right now, in order to force a sale of the real property. And then on page 182, they say, we believe judicial foreclosure may be PDS, that's Plaza del Sol, PDS's best option. So it was recommended.
But at some point, counsel, didn't Plaza agree to accept the proceeds from the sale to Alliant as a payoff of the outstanding loans?
Yes. This was an attempt to try to settle an obligation.
Okay.
And
so they reached agreement on that, and that's what led to him making the demand statement to the escrow, right?
Yes.
Okay.
Yeah. And so this demand statement.
So then, how do we square your position with the Allstate versus Rubin case that says when a cause of action arises from conduct that will lead to litigation only if negotiations break down or contractual commitments aren't honored, future litigation is only theoretical?
Here
How
it
do I
was
square that?
based on the facts that there are memos that are saying like in this same memo, the Christopher Lamb memo, they say on page 179, finally, although a formal notice and demand for full repayment of the obligation is not required before commencing judicial foreclosure, such notice may be advisable as a means of gaining leverage in any ongoing negotiations. So this invoice was submitted as if they had not paid that, our client would have sued to recover that. Those were fees that our client was entitled to in addition to the full amount of the debt.
But wasn't it submitted pursuant to the parties' agreement to accept the proceeds from the Alliant sale?
It was filed as part of this attempt.
They had reached an agreement that Alliant's going to buy this property, it's going to yield, $50-some million, and we'll accept that and be done with this.
Yes, and if you pay these attorney's fees too,
Right.
yes.
Right, that was part of the deal.
It was
Okay.
part of the deal, but the deal had not been consummated until the property was sold and this was paid. They're saying that they didn't even know how much these attorney's fees were. That's what they say in their declaration from Mr. Hera. He said he read it, he saw it, and he felt like he needed to pay it right then and there. So that could not have been sent other than as part of an ongoing negotiation to avoid litigation. Because if he didn't know that $24,000 was a number until he received that demand, then there was no firm deal on that at that point. Because if he had they say that their entire cross complaint is based on the idea that this was too much, that we were demanding too much. And if that were the case, then if they really thought that, then that means that deal hadn't been consummated, hadn't been finished yet, hadn't been performed anyway. We made this demand, this $24,000 demand, as part of litigation or it's reasonably relevant to litigation that was contemplated. Our client in that memo, in the internal deliberations, they anticipated filing suit, judicial foreclosure. Then they tried to come to a deal. Part of the deal was that they would pay the attorney's fees. We submitted a demand for attorney's fees. This is part of that, still these demands. If they had refused that demand, our client would have filed suit. This was part of trying to settle a dispute. And the fact that we had sent that demand didn't, at that point, let's say they'd even agreed to it and said, yes, $24,000. That there was still litigation that was reasonably contemplated, as shown by the memo. So the act of signing.
What's the date on the memo that you've been reading from?
The date on the memo is May 22nd, 2020.
And when was the deal struck to accept the proceeds from the Alliance sale?
I don't have an exact date. The escrow, when this demand was sent was October 16th, 2020. So presumably sometime in between there. And I can't say for certain that there was I don't think there was even a signed agreement on that. I don't know. It's not, it wasn't in either side's briefing about the record. All we have, and that's one of the issues here, is that the evidence that's been submitted here, the supporting and opposing affidavits, the evidence is undisputed that what I'm saying is correct. We have a litigation memo. We have a declaration from our attorney saying what he had recommended to his client. We have the contemporaneous emails inside of my client's structure saying that we're threatening lawsuits. And then we have a demand for payment. And we have everybody on my side describing that as a litigation demand. Now, they have submitted one declaration from their client that doesn't refute any of that. Doesn't deny that this was sent in anticipation of litigation. I'll reserve my remaining time. Thank you.
Respondent?
Good afternoon, Your Honors, and may it please the Court. Joelle Lieb for Respondents, OC Media Tower and OCR Land. The central question for the Court to address in this case is whether an invoice transmitted in the ordinary course of business qualifies as a protected communication under the anti-SLAPP statute. Simply put, the transmission of an invoice in the ordinary course of business does not qualify as a protected communication made in anticipation of litigation. The Court should thus affirm the trial court's ruling denying appellant's anti-SLAPP motion for the following three reasons. First, while demand letters and like communications may qualify as protected communications made in anticipation of litigation, the invoice here is not such a communication. Second, even if the Court considers appellant's proffered evidence, appellant Galuppo's self-serving declaration and the internal litigation strategy memo do not transform the invoice into a protected communication because one side's subjective belief that litigation may occur is insufficient to show that litigation was imminent rather than merely theoretical. Third, respondents' causes of action for fraud and money had and received more than satisfy prong two's requirement that the non-moving party's claims have the requisite minimal merit. First, appellants fail to carry their burden at prong one to show that the invoice qualifies as a protected communication made in anticipation of litigation. The anti-SLAPP statute provides that any written or oral statement made in connection with an issue under consideration by a judicial body is a protected communication under subsection E2. The statute only protects communications made when litigation is no longer merely theoretical, but rather has ripened into a proposed proceeding. Communications indicative of a proposed proceeding include pre-litigation demand letters and like communications. Here, however, the invoice only contains a line item for the total fees sought, as well as a very general description of the legal services rendered. It was sent in the ordinary course of business to close a real estate transaction. On its face, the invoice does not suggest or threaten that litigation will result if respondents fail to pay the invoice. The invoice thus was not transmitted when litigation had ripened into a proposed proceeding. On this basis alone, the invoice cannot qualify as a communication made in anticipation of litigation.
Ms. Lee, good afternoon. You heard Mr. Watts' answer to my question. I'm going to ask you the same question. Does the record show any demand for payment or any mention of litigation other than And you feel free to address what he said in his response.
No, the record does not. So if we look at even the September 18th letter that counsel referenced, that letter does not threaten litigation at any sort, and the email communication discusses potentially that perhaps they were contemplating foreclosure, but that's unrelated to the any litigation over the discrete issue of payment over the attorney's fees. And I'd also mention that under the case that Justice Gooding referred to, People ex rel Allstate Insurance Company versus Rubin, appellant carries the burden to show that the pre-litigation statements were made in good faith anticipation of litigation at the time the statements were made. Both of those communications that counsel referenced were made in September and October of 2019, which is over a year prior to when the invoice was transmitted in October of 2020. So on that basis alone, I would say even if we're considering the evidence that they submitted, which respondents objected to at the trial court, so even considering if it's admissible and considered, it still does not show that litigation had ripened into, or that the dispute had ripened into a proposed proceeding at the time that the invoice was transmitted.
You mentioned the potential for judicial foreclosure proceedings being initiated was different than any claim with regard to the attorney's fees. Is the potential for judicial foreclosure proceedings also different than Plaza's lawsuit for fraud? Is that saying one and the same thing?
Correct.
Thank you.
Your time has expired.
Oh.
If you want to make a last statement, that's fine.
Lastly, I just say on prong 2 that we more than satisfy the minimal merit standard because we've cited to evidence in our brief showing that there were approximately 5 hours of time that was billed for that was completely unaccounted for, so that supports respondents' claim for fraud and money hadn't received, that the invoice was fraudulently inflated. Thank you, Your Honors.
Thank you, Ms. Lee. Mr. Watts, anything further?
So, Your Honors, first, this invoice was not sent in the ordinary course of business. You buy something at a store, you hire somebody to come to mow your lawn, they give you an invoice, you pay it, you invoice, pay it, invoice, pay it. That's not what this was. These were invoices for attorney's fees, $24,000 in fees that were incurred because they didn't pay. There had been an ongoing breach of their agreement to pay tens of millions of dollars in loan for over a year before this invoice was sent. This was a demand, a final demand before our client would judicially foreclose. If they didn't pay this, we'd proceed with action. They mentioned the judicial foreclosure. They asked if that was distinct. It's not distinct. The judicial foreclosure is what would trigger our client's right to recover fees. If we foreclose on those notes, that's how we're entitled to fees. We aren't just randomly entitled to fees. We're entitled to fees if they breach an obligation to us. We file a lawsuit, then we file a fee motion. That's normally how we get these fees. It's just like a personal injury case or an ADA case. Somebody files an action under the ADA. They ask for $4,000 in damages plus attorney's fees. They wouldn't be entitled to those attorney's fees normally. It's only if they win that lawsuit. That's why they demand those fees. That's why we demanded these fees, because litigation is how we would have to get those fees if they didn't pay them. They said litigation is, was theoretical. It's not. We're here. This is the litigation. So it wasn't theoretical. Digerati, which we cited in our brief, says that if there's a lawsuit that's actually filed on the same obligation, it shows that litigation wasn't theoretical. We also have all these memorandums explicitly recommending that we file litigation. They say that self-serving declaration from an attorney is not sufficient. It's not sufficient standing alone, no, but we have contemporaneous emails from our clients discussing it. Wilson versus CNN says that a defendant's motives do matter, that the court needs to look at those affidavits when deciding whether it was sent in anticipation of litigation. Bel Air versus Morales, the actual subjective intent, that's a quote, of the defendant matters when we're considering whether they sent it in anticipation of litigation. We are, Equilon Enterprise, again, says that you can't just look at the face of the invoice. She's correct. On the face of the invoice, doesn't look like a litigation demand, doesn't look like it has any reasonable relevancy to litigation. That's why the Supreme Court mandates that we look at the supporting and opposing affidavits. Equilon Enterprises says when you look at those, and those show that that's why this was sent, then it was sent in anticipation of litigation and satisfies prong 1. Doesn't make it completely immune from liability. That just shifts the burden to prong 2, and then we do the prong 2 analysis. Finally, on the prong 2 analysis, they said that their evidence shows that there were inaccurate billing statements. They didn't submit any of that to the trial court. There's no evidence whatsoever on prong 2. They submitted one piece of evidence in this litigation, and that was Michael Hara, and he doesn't deny that our invoice is accurate. We submitted evidence saying it is accurate. They have no evidence, as opposed to argument, saying that it's inaccurate. That means that the evidence is accurate. That means that fraud is impossible to prove. So we'd ask the court to reverse the trial court and grant the anti-SLAPP motion, unless there's any questions.
I'm not hearing any.
Okay, thank you, Your Honor.
Thank you both. The matter is submitted. There'll be a very brief recess for a panel change.
All rise.